Right, are you Jim Eldred?
Yes.
Willridge? So we're here. Mr. Willridge has he's on probation in 3 cases, 18-28743, 28744, and 30139. And then there's a new offense, a burglary of a habitation, in cause number 25, DCCR 1804. And there was an agreement that was reached, and he entered a plea of guilty to that burglary of a habitation case. The agreement was for a 10-year deferred probation, restitution to be determined, and that those motions would be dismissed. There was an issue between, obviously, when he pled and now, which required me, I revoked that bond because he was arrested on May 26th in Chambers County for a 3rd-degree felony and a Class B misdemeanor. So obviously that
kind of nullified from all of our position where we were with that agreement, Judge.
Right.
So you know.
Okay, so where are we? I mean, I'm going to at this time reject the agreement formally so we can start all over. You guys negotiate whatever y'all want to do. If we need to get more information about that Chambers County case, but obviously I'm not inclined at this point. I see no reason if those allegations are true, that Mr. Wilbridge would get another opportunity on 3 felony probations with now the new burglary of habitation here. And while literally days after he entered pleas here, went and was at a minimum in a county that he wasn't supposed to be in without permission and arrested for those offenses. So my thought is, do you have any information on those yet?
No, Judge, because when we broke last time, it was primarily, obviously not knowing that was gonna happen in Chambers County for the restitution in the burglary. Because
Right.
we all had the discussion about how could tennis shoes cost that much.
Right.
And I have spoken several times with Mr. Riley, who the court knows is an excellent PSI writer. And he assures me, and through an affidavit from the complainant in that case, that that's what the restitution amount is. So I feel like we could ask for that and see if he'll pay it, and so be it. Then obviously the new offense came up, which then put us all kind of back at square one. The court is aware that I have always been a little bit more outgoing with Mr. Wildridge, wanting to give him an opportunity. I'm not suggesting I still don't want to do that, but I certainly understand the position that we're all in. I mean, the files are just stacking up.
Yeah.
And
I mean,
And Judge, only thing I can say in that regard is that, you know, of course, I've dealt with him for a long time in this situation, and you know, he understands it was inexcusable for what happened in Chambers County. But I will say that it's the first time that since then that he's actually opened up to me as far as asking for the type of help he needs for any underlying issues that may be there. And it's something that his family was actually in the position to try to get started when, of course, when the whole bond situation occurred. But of course, he turned himself in, you know, did what he's, you know, complied with your orders.
And that, per our conversations, I think, Judge, it's important to note that that has to do with underlying mental health issues that go directly in correlation to his behavior. Although it doesn't excuse his behavior.
no, it
Yes,
doesn't. And I guess, I mean, you guys know, I mean, he's been on probation since 2018.
Right.
There's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. It's been years that we've gone through motion to revokes that have been dismissed, and
I mean, the only thing I can say is a lot of times in these type of situations, of course, the help doesn't work unless the person is ready for it. And of course, like I said, this is the first time he's opened up to me as far as trying to get that. And a good thing for him, he does have the support system there that he can try to get that help.
and that's so great. And it's also such a shame at the same time, because I'm guessing he's had the same support the whole time. It's not like people are just now stepping up and saying, let's help him out, right? I mean, they've been there the whole time. And here we are with our 5th felony in Chambers County while you're on probation for 3 here. Here's what I need. I'm not gonna do anything today. I want to find out, see what you guys can find out about Chambers County, what the status of those offenses are, get Mr. Lewis whatever you can.
Okay.
So that I can also have a little, even if it's just a PC, so I can see a little more about what the underlying offense allegations are, and then we can kind of reconvene and I would do see, I guess, where if you guys want to try to tell me what some agreement is, I'll see if I'm willing to go along with it or not. Obviously probation, I value your opinion, and so
More likely than not, Judge, if it's okay with the court, probably will not come to you with any type of agreement, maybe just more of a conversation. Obviously, we're all aware of the situation that all of us are in right now with respect to individuals this age that have been given multiple
Yeah.
opportunities and what else going on. So I don't.
we're also going to go through, we can do it. I don't know, there probably needs to be amended motions on those 3.
To add those.
To
okay.
add those allegations, and I'm not gonna just sign a dismissal on those motions. I want to go through each and every allegation of the motion, get pleas of true or not true, and then we'll go forward. So between now and then, if you can get, I guess,
Sure.
any type of hearing done so that we can get those new allegations in the hearing, in the motions to revoke, we'll go through those at the next court date, and then we'll see where we are from there.
You get that.
Okay.
problem with-
All right, thank you. Go back to the bailiff. For DCCR 0544, Mr. Harrison had already entered pleas of true to counts 1, 2, 3, 7, and 8. And you guys have visited, I guess, about my unwillingness to accept the plea agreement, and if you come up with some other agreement.
Yes, sure, we have
And what is that?
for 8 years.
And Mr. Harrison, is that your understanding, and is that your agreement?
No.
And so with everyone's permission, can I make that modification on the agreed punishment
Your Honor,
recommendation?
you said no.
You said no?
Yeah.
Oh, I thought he said yes.
I said, yes, ma'am.
He said yes.
I heard it wrong.
Sorry about that. It's scary.
That's okay. So, can I make that modification on this document?
Yes, ma'am.
Okay. So I have, here, Mr. Harrison, on the tablet, some documents that have your signature on them. I've made that change to show that the agreement is for 8 years instead of 5. Before you went over and signed these, did you go over them with Mr. Lewis? Do you fully understand all the documents you signed? And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal? State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Harrison is not competent?
No.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and are continuing to use them and possess them. So take advantage of the time that you have, do something better with your life. And when you get out, don't possess a gun. Don't be around anybody that's possessing a gun, because if you are and you're here in Jefferson County, it's going to be a whole lot worse than today. Do you understand?
Yes, ma'am.
All right, good luck to you. You can go back with the bailiff.
Priors make him habitual by law, but he didn't receive even half the time he is on this case
Okay.
on those.
All right, sir, are you Donald DeRusso? And will you mind waive the formal reading of the indictment?
It will, Your Honor.
Mr. DeRusso, in cause number 26 DCCR 0758, you're charged with the state's going to proceed on count 1 only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 9th of 2026. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes,
And are you pleading guilty because you did what they've charged you with?
yes,
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
yes,
Do you fully understand them?
yes,
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
yes,
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes.
State tenders number 1,
No objection?
it's admitted. Is there any evidence that Mr. DeRusso is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Oh, wait, and I am making an affirmative finding of a deadly weapon. All right, you can go back.